Citizen Action Defense Fund and Executive Director Jackson Maynard today filed a legal challenge to the income tax. And again, it was in Klickitat County Superior Court where this has been filed. That's in Southeast Washington in Goldendale. And two of the plaintiffs in the case reside there in Klickitat County. And the challengers can potentially find a more favorable court outcome than on this side of the mountains. That may have played into some of the decision on which court venue to file in. I know that was one of the considerations. So we're going to break that down for you now. So at the core of the lawsuit filed today is whether income is considered property, which some Democrats argue it is not. Rob McKenna, former state attorney general, says the Constitution is clear here in the state of Washington, and that people have a property right to their income. So my income, my bank account, just like my home, my car in the driveway, is my property. It is mine. And the Washington Constitution says we could institute an income tax, but it would have to be uniform, and it would have to be by our current state constitution limited to 1%, unless you amend, again, the state constitution to make it differently. So that's what's different this time around is there's no attempt by those who've backed Senate Bill 6346 for the income tax, the tax on millionaires. There is no attempt to amend the state constitution to do it. It's just basically pass it. Might be unconstitutional, but it's going to be the courts that ultimately decide. And that's kind of been the route. So Governor Bob Ferguson has said he believes that the court is going to rule in their favor and that this is the time to push this. Given the current makeup of the court, that might be the case. But remember, we have 5 positions on the current state Supreme Court that could be changing sides. Maybe you're going to have a more conservative court, or at least a couple of more members of the court by the time this legal challenge reaches the state Supreme Court. So that is certainly something to consider in all of this. Now, we, on the last couple of days of session, had an opportunity to be in the governor's conference room as he signed this bill, 6346, for the income tax, and some of the other last minute bills to be signed into law. And one of the reporters who gathered with him after kind of pressed him on this and said, what do you think about all the legal challenges coming to the income tax?
They'll have their day in court. As it should be. They'll have their day before the people. Totally appropriate. I'm very supportive of the initiative process, and I think that people should weigh in on this. The Supreme Court should weigh in on this. So I've got zero issue on that, and I feel confident going forward.
Now, in this morning's press conference, where we were given an opportunity to ask some questions, I had a chance to ask former Attorney General Rob McKenna about Governor Ferguson's recent comments, because Governor Ferguson told a local television station that I've been on the opposite side with McKenna many times when I was AG and never lost a case when McKenna was litigating the other side. So I asked Rob McKenna about that somewhat personal attack, I guess, if you will, from Governor Ferguson in this morning's press conference. And this is what he said.
I think it's very telling that Bob wants to personalize this and doesn't want to address the legal issues involved here. He was Attorney General. He's a lawyer. He understands what it means to have plain language in the Constitution and to have a series of Supreme Court decisions. This is not a boxing match. This is an important question of law, but he doesn't want to talk about the law. Instead, he signed into law a bill that clearly violates the law today, which is why he and the legislators who voted for it need the Supreme Court to change the law for them. And as of the day they voted for it, it was illegal. It violated the Constitution. And unlike former governors like Dan Evans, who had the courage and political skill to put together a coalition to put this to the voters as a constitutional amendment, Governor Ferguson was unable to do that. And the legislature was unable to come up with the votes to send a constitutional amendment to the voters either. Instead, Governor Ferguson and the legislature are working hard to keep this issue away from the voters. And all voters ought to be very concerned about that.
Now, former Democrat state senator and former state Supreme Court Justice Phil Talmage has joined the fight alongside former AG McKenna and Citizen Action Defense Fund. Now, specifically, Talmage is representing his client in this, one of the plaintiffs, which is the Ethnic Chamber of Commerce, and a number of small business operators that fall under that umbrella who are very concerned that they're going to be hit hard by this income tax. And so I spoke with Talmage after today's press conference.
The communities we're talking about are people that are largely small businesses that are aspirational. They want to grow. They want to expand their businesses, and they want to generate, significant income. So they do that. And what's the response from the state? Well, we're going to not only tax you in your business capacity, but we're going to tax you on your income. And they're concerned about that. I mean, it's a problem for them, and it's something that is a deterrent for them to do greater achievement than they've already done and have proven over the years. The Hispanic folks and people from the Asian Pacific community both have been remarkable in their efforts to take a piece of the American dream and run with it.
Now, Democrats, of course, say that this tax is needed to address what they call a regressive tax system in the state of Washington, where they contend that the richest are not paying their fair share. Critics say not only is it against the state constitution, but that it will open the door to a tax on the income of all Washingtonians. And now remember, we also have Let's Go Washington and founder Brian Haywood asking the state Supreme Court to let them run a referendum campaign. We talked about this last week. Secretary of State Steve Hobbs refused to process Haywood's referendum request, telling the Center Square that, since the bill was written to be sort of referendum proof, it's deemed necessary for the budget. You can't let voters weigh in. So he just kind of summarily dismissed it. The Secretary of State did. So Haywood has gone back to the state Supreme Court and said, wait a minute, he was completely out of line here in dismissing an opportunity for the voters to weigh in. And Haywood's sense is that the interpretation of the Secretary of State on what our Constitution says to make something referendum proof is wrong. It should be an emergency and necessary to implement the budget, not one or the other. And that's the contention of Haywood in his challenge to the state Supreme Court. And then, of course, also coming from Let's Go Washington, likely a couple of initiative campaigns, likely one that goes directly to the legislature and one that goes directly to the people, bypassing the legislature. Those initiatives require far more signatures than a referendum would. A referendum would only require a couple 100,000 signatures. You might need twice that or close to twice that, assuming you've got, some invalidation rate for folks that sign to get an initiative qualified to the ballot. But both of those paths are likely this year. So things are moving still rapidly. Multiple lawsuits, a challenge request to the secretary or to the state Supreme Court from the Secretary of State's refusal to process the referendum, and then the initiatives to come. So much to follow on this, and it is changing literally several times a day.